Engineers Geoscientist Manitoba governs the practice of professional engineering and geoscience through the Engineering and Geoscientific Professions Act and the Engineers and Geoscientists Manitoba bylaws. These important pieces of legislation are constantly evolving to ensure that the association can fulfill its mandate of regulating engineering and geoscience, promoting knowledge, skill, and competency of its practitioners, and to advocate where the public interest is at risk. Changes to the Act will be coming into effect on November 1st, 2023, and proposed changes to the bylaw to support the Act changes will be put to a vote by the membership in September of 2023. My name is Danielle Unette, and I'm the Standards Coordinator at Engineers Geoscientist Manitoba. This video will go over the upcoming Act changes and bylaw proposals. The Association, along with members, government, stakeholders, and legal counsel, have been working on updating the Act since early 2019. The Act changes through Bill 233 received royal assent in November of 2022 and were officially proclaimed on May 17, 2023. They will come into effect on November 1st, 2023. The Act amendments are meant to simplify administrative procedures and language, reduce barriers to practice, increase transparency, and enhance the protection of the public. The proposed bylaw changes will provide further details to support the Act changes. A major Act change is an overhaul of how appeals are handled by the Association. Currently, appeals of the Discipline Committee and of the Registration Committee can first be appealed to the Engineers Geoscientist Manitoba Council, then to the Court of King's Bench, and then to the Court of Appeal. Decisions of the Investigation Committee are appealed directly to Council. The new Act change creates an internal appeal committee. This committee will hear appeals of decisions of the Registration Committee and the Investigation Committee. Discipline Committee decisions will be appealed directly to the Court of Appeal. This change brings the Association in line with other jurisdictions while reducing costs, removing the burden from Council, and ensuring that the appeal process is efficient and effective for all involved. Proposed changes to the bylaws add references to the new Appeal Committee and update the wording to reflect the new Appeal Committee processes. A new section of the bylaws outlines the Appeal Committee's constitution, conflicts of interest, communication, processes, and policies. The Act change now allows the Association to publish the names of practitioners who are suspended due to non-compliance with the Professional Development Program and notify the employer of a member whose license has been suspended due to non-compliance with the Professional Development Program. This change also makes it permissive for the Investigation Committee to publish the name and information about the decision of a charge, conviction, penalty, voluntary withdrawal, or formal caution. The proposed changes to the bylaws will allow the Investigation Committee, in certain circumstances, to use their discretion when it comes to publication. They could choose not to publish in certain circumstances, such as when a member voluntarily withdraws their membership due to a medical condition, or they could publish anonymously if they believe other members could learn from the outcome of the decision. This will not affect the publishing of disciplinary committee decisions. The Act changes explicitly allow for the Investigation Committee to investigate other matters related to skill in practice or professional misconduct that may arise during an investigation. This power previously existed in bylaw and is now enshrined in the Act. The Act change empowers the Registrar to approve Certificate of Authorization applications and Canadian Mobility applications. This change means that mobility applicants and Certificate of Authorization applicants would not have to wait for a monthly Registration Committee meeting to be approved, improving application processing efficiency. There will still be circumstances in which it is not appropriate for the Registrar to approve a mobility or Certificate of Authorization application, such as when there is a conflict of interest. The proposed changes to the bylaws would outline the situations in which the Registrar could not approve an application and the process for when that happens. Changes to terminology and definition now allows licensees, which now includes temporary licensees and specified scope of practice licensees, to hold a Certificate of Authorization. This change also clarifies that titles such as Engineering Licensee, Geoscience Licensee, Eng.L. and Geo.L. are protected titles. Proposed changes to the bylaws reflect the updated terminology. The complete wording for the upcoming Act changes and the proposed bylaw changes can be found on the Association website. If you have any further questions, please don't hesitate to reach out.